And so,
But isn't that what it's being alleged here? I mean, I appreciate that distinction, but I guess I'm not sure I understand what you mean when you talk about the distinction. I mean, the allegation in this case, and you could imagine even hypothetically, is that the union certainly has the right to walk away.
yes,
And if they're walking away, and their responsibilities involve perishable goods
Yes.
that as a result of their walking away are going to spoil,
right?
then that's an incidental harm that is occurring. But you can also imagine a situation in which the union says, we have evidence that we're going to time our walking away
Yes.
at the very point in which we've poured the thing that can't be recovered, because if we do it at that point, we're going to destroy the machines, and that is our intent. I don't understand how that is protected and why that isn't any, the same as the arsonist who says, I'm going to walk away, but as I do, let me strike the match and burn down the factory.
So what's always been critical to the board's cases is the extent of the harm. So the aggravated nature of the harm, the foreseeable imminence of the harm, not the intent.
But I'm asking what should be. I appreciate that it hasn't been clear, but that I think is part of the problem. So in terms of the logic of this, shouldn't the line be drawn around the intent in the sense of, is the union engaging in conduct for the purpose of destroying the property of the factory, or is the union just striking, and if some of the property gets damaged because they're walking away, that's incidental, that's totally protected?
So that should not be the test for two reasons, a doctrinal and a statutory. So let me give you the statutory first. Congress in Section 151, the very first section of the Act, observed that strikes generally have the, quote, intent or necessary effect, close quote, of causing a variety of economic harm, including a stoppage of the flow of raw materials and interruptions of operations. And certainly Congress was aware of perishables like cheese and milk and concrete in 1935.
Okay, but that's still not getting to me. Yes, economic harm is being inflicted when you stop work.
Intentionally.
You intentionally stop the work. But the question is, can you do something that actually intends to affect the property directly, to make it the property unsalvageable? We can't get new people in here as a result of the strike and pick up where we left off because you've literally burned down the factory. We agree that you can't burn down the factory, right?
We absolutely agree you cannot burn down the factory.
All right.
You cannot smash things.